What if the evidence that could save your life was locked away, not because it did not exist, but because the law would not let you test it? Today, we're exploring Gutierrez versus Saenz, a 2025 Supreme Court case that sits at the crossroads of DNA testing, death penalty eligibility, and the right to due process. At its core, this case asks, can a person sentenced to death be denied access to potentially exculpatory DNA evidence simply because of how a state law is written? Let's start with the law in question, Texas's Article 64, a statute that governs post-conviction DNA testing. Under this law, inmates must prove that DNA results would have prevented their conviction, not just impacted their sentence to qualify for testing. That's a high bar, and one that essentially slams the door on people trying to challenge their death sentence instead of the underlying guilt. This is where Ruben Gutierrez comes in. He wasn't trying to prove he didn't commit the crime. He was challenging whether he should be executed for it. Gutierrez argued that Texas's strict rule denied him due process by blocking access to evidence that could be critical to his punishment, even if not his guilt. The district court agreed, finding it unfair that Texas allows death sentence challenges through habeas petitions, but blocks access to DNA evidence that might support them. But the Fifth Circuit reversed, saying Gutierrez lacked standing, because even if the court ruled in his favor, the prosecutor might still refuse DNA testing. That brings us to the constitutional issue of standing, which requires three things: an injury in fact, causation, and redressability. The Fifth Circuit zeroed in on redressability, arguing that the outcome wouldn't necessarily change anything, since the prosecutor could still say no. But the Supreme Court had already addressed this issue in Reed v. Goertz, a 2023 case involving the same Texas DNA testing law. In that case, the court ruled that redressability was satisfied because a favorable ruling would remove the prosecutor's legal excuse to deny testing. Building on that precedent, the Supreme Court in Gutierrez reversed the Fifth Circuit. They held that Gutierrez did have standing. Why? Because the harm came from the law itself, Article 64, not the prosecutor's personal judgment. A court ruling striking down that law would remove the unconstitutional barrier. The court also addressed whether the case was moot, since the prosecutor refused to allow testing even after the district court ruled in Gutierrez's favor. But the court rejected that argument, saying you can't dodge judicial review by promising to reach the same conclusion no matter what the court says. That would gut the purpose of constitutional checks and balances. Not everyone agreed. The dissenting justices believed Gutierrez still lacked standing. They argued that because Texas courts used multiple reasons to deny testing, not just Article 64, a ruling against that single law wouldn't necessarily change the outcome. They also questioned if there's even a liberty interest in state-run processes like post-conviction DNA testing under the Constitution. That's a critical philosophical divide. Does liberty under the Due Process Clause include rights created by state statutes? The majority said yes. If the state offers a process, it must be fair. The dissent said no, arguing that liberty means freedom from physical restraint, not access to legal procedures created by the state. The Texas Court of Criminal Appeals played a central role here, consistently rejecting Gutierrez's requests for testing. The Supreme Court's decision indirectly rebukes their interpretation of Article 64. So what does this ruling mean going forward? For death row inmates in Texas and possibly in other states, it opens the door a little wider to post-conviction DNA testing, especially in cases where the death penalty, rather than guilt, is at issue. But it also signals more litigation ahead, as courts try to balance finality in criminal judgments with the pursuit of truth. Gutierrez versus Saenz doesn't guarantee access to testing, but it does say this: a state cannot block the courthouse doors by hiding behind an unconstitutional law. And that's a powerful message about due process, justice, and the life or death consequences of getting it wrong.